Okay, so as a brief introduction to natural assets management. So nature and natural assets provide a wide array of services on which all of us rely. Some of these we could call infrastructure services. For example, a wetland complex providing drinking water filtration or stormwater management. Others might be non-infrastructure, such as a park that's cooling the city or providing recreational amenities. And of course, many natural assets. So again, here we can think of forests, wetlands, foreshores, stream corridors, provide both infrastructure and non-infrastructure services. However, most local governments and most public and private sector entities, for that matter, aren't really thinking about nature in this way. To the extent that most entities are considering nature at all, they're thinking about it as a green or a social or a recreational amenity. And this creates a few issues for us. It means that every hour of every day, local governments, but many others, are taking land use, zoning, planning, investment, and other decisions without fully understanding the array of infrastructure and non-infrastructure services that they're getting from nature and the impact of their decisions on nature and thus on those services, nor really whether their actions are degrading nature to a point where some of the services upon which they rely are becoming threatened. Why do we care? Well, it depends a little bit on one's perspective. Most people in this room or on this call face infrastructure challenges. Every community in this country has engineered assets that are aging, where the maintenance has been deferred, the stock needs renewal. And the reality is that in a rapidly changing climate, we cannot simply build our way out of this crumbling infrastructure crisis. But really, the promise of natural assets management is that we may not need to. Solutions, if we choose to accept them, are all around us in the form of forest stream corridors, foreshores that can provide many of the same services cost effectively in a changing climate and form an integral part of a resilient infrastructure system. And of course, provide many of the other benefits that make our communities worth living in. So that's at least one reason, very operational reason why these issues related to natural assets are important. The other is that if we zoom right out, there simply is no way that we meet our net zero targets by 2050 without healthy, connected, biodiverse ecosystems. That's one singular challenge, not two separate challenges. And most recently, in Montreal last year, in the Kunming Global Biodiversity Framework, there was a call for local governments, for cities to take transformational action to protect, manage nature, to protect biodiversity. So how does all this tie together today? Well, the good news is that in Canada, local governments, and in fact, all public sector entities, are mandated to manage their assets using modern structured asset management. This has as its central organizing principle the idea of sustainable service delivery. So this means that if somebody is the director of finance or engineering or the mayor or the manager of public works, they don't really need to worry so much whether or not their service is coming from a, quote, green asset or a gray asset, only whether or not that service is cost effective and reliable. And what we're finding is that asset management lends itself extremely well, therefore, to also conceptualizing and accounting for and managing nature and managing natural assets. To date, roughly, just working with MNAI alone, about 100 to 120, depending on how you cut the numbers, 120 local governments, but increasingly others have started to undertake natural asset management. We're also working with First Nations, conservation authorities, ports, and others. I won't get into it today, but there's also a lot of work going on at the level of norms and standards to help make this work mainstream across the country. So natural asset management, therefore, is a process by which we can understand, account for, and ultimately protect nature for the full range of services that it provides. And I would argue that it's starting to come into its own. And by this, I mean that a growing number of local governments, public sector entities, and others are starting to think about how they can integrate this practice into their decision-making beyond innovators, beyond early adopters, and are beginning to find that indeed they can provide cost-effective and reliable services in a changing climate through nature and through the management of natural assets. There's, of course, many dimensions to natural asset management. There's ecological and financial, there's ecological issues, there's financial issues, there's accounting issues, to name just a few. Today, the point of this discussion is to look at the legal dimensions of natural asset management. Probably all of you have heard, at least in passing, of court cases related to climate change, or class action suits related to nature and the latest, unfortunately, latest climate disaster, or possibly even some cases that give rights to nature. The work that Ian is about to present to us really tries to make sense of this rapidly changing legal landscape and to shed light on questions such as what are the legal authorities for local governments to actually undertake natural asset management? What are the risks to doing it? What are the risks to not doing it? So those are some of the questions we're going to be digging into today. I have to be clear that we're not providing legal advice. This is a legal primer, but it is not legal advice, nor was it within the scope of this project to address, for example, Indigenous rights or to do a deep dive into any one area. So this is only a primer and it's only a first step. Nevertheless, we hope it helps you to navigate the changing legal world around nature and natural assets as some, and hopefully many of you, begin to embark upon your own natural asset management journey. And with that, I'd like to thank you and to turn it over to Ian for his presentation.
Thank you very much, Roy. Good morning, good afternoon, everyone. Thank you so much for attending today's webinar. As Roy mentioned, my name is Ian Moore. I come from a settler family that lives primarily in Anaskwaski Waskahegan, which is, I understand, to be the Cree word for Beaver Hills, which is where Edmonton, Alberta is now located. However, I now live and work on the traditional and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. I am a lawyer by trade. I practice as a sole practitioner in the areas of local government law and environmental law, as well as with Arbutus Law Group in the area of Aboriginal law, working with First Nations governments across the country. Roy did a wonderful job priming you for this primer presentation. And so maybe, Roy, if you could go to the next slide here, that would be fantastic. Excellent. So just to start us off, I want to give us some clear expectations and boundaries around what this primer is and what this primer is not. It officially launched today. I believe you'll be sent, if you've not already been sent, a copy of the primer by email. But what this is a high-level assessment of what the law says in relation to local government natural asset management. As Roy mentioned, it's general legal information and not legal advice. We have drafted it and scoped this so that it covers principles applicable across the country. However, where it's specifically relevant, we've focused on 4 sample provinces: BC, Alberta, Ontario, and New Brunswick. I want to acknowledge right off the bat that there are certain municipalities across the country that have their own legal regimes where what we say today might not apply. Those include Vancouver and Toronto, which have their own enabling legislation. There are also specific types of local governments other than municipalities that may have specific legislative regimes that deviate somewhat from what we say today. And then finally, we don't really touch upon Quebec, which has its civil code. But in general, the legal principles we talk about today will apply across the country. But we encourage you to consult your own legal counsel for their application should you want to take this legal primer forward. Another aspect to this, and just moving on to this next slide here, another aspect of this, as Roy suggested, is that this is just a start to some of the legal resources that the Municipal Natural Assets Initiative will be developing. And so we're very keen to hear from you either today or at any point in the future about other types of resources or more targeted types of resources that you would find useful to take the knowledge that's set out in this primer to apply it to your specific circumstances. So you can see this as a start of a conversation that we hope to have for many, many years going forward. And finally, one other contextual note here is that there's a distinction being made in this primer and in the conversation we're having today between the environmental regulation and management activities of local governments and municipalities that already take place and natural asset management. Pretty much every local government across the country will have devoted staff or departments to complying with and enforcing environmental regulations, environmental legislation, in putting forward the environmental policies and priorities of a local government. What natural asset management is a subset of this. It's looking at what natural assets do local governments rely upon for service delivery. How can you calculate and accurately understand the value that those natural assets provide? And then how do you protect that in a systematic manner, either as part of an asset management framework more generally, or as a distinct asset management framework that's focused solely on natural assets. So a lot of these legal principles, they apply to environmental management more generally, but we don't cover, the legislative scope or jurisdiction of local governments to the environment generally. That is a very big topic, and there are lots of resources that we point to in the primer that you can look at if you want more information about this, but this is specifically focused on that natural asset management component of that umbrella of environmental management. All right, our next slide here. And so what this legal primer does is accomplish 4 objectives, or it aspires to accomplishing these 4 objectives. The first is to give you a sense of the legal authority that local governments in Canada have to undertake natural asset management as a distinct practice. Some of the legal and policy tools available for local governments to undertake natural asset management. An elaboration on what some of the legal risks facing local governments are that engage in natural asset management and those that do not. And then some of the legal developments that local government should be aware of that will likely affect how the law applies and relates to natural asset management by local governments. And so some of these this next slide, Roy touched upon. But what we want to do is, the law is not an isolated instrument. It's not an isolated phenomenon. It operates within a larger context. It's generally responsive to that larger context. Some might say a little bit slow to be responsive to that larger context, but the overarching principle here is that there are lots of things happening in the world. There's lots of things that Canadian governments, the provincial government, local governments, Indigenous governments are being responsive to right now. And we want to highlight that natural asset management is part of that framework. It's a response to a lot of what's happening in the world right now. It's a response to the biodiversity and climate crises that we are facing right now. It's a way to help accomplish the net zero by 2050 goals of Canada, of the globe, the 30% by 2030 protection, 30% of conservation protection by 2030 goals set out in the recent global biodiversity framework. And it's also a way to respond to the infrastructure deficit that is currently being experienced across the board in local governments across Canada. And so what we want to kind of highlight here is that there is an overarching context that this is operating within, and it's not just about what can local governments do, what must local governments do, but how can local governments respond to these overarching social, environmental, and economic pathways that we're all on right now. So the meat of our primer. What can local governments do? Where is the local government authority for undertaking natural asset management? By and large, there is little in the way of explicit direction provided to local governments across the country, setting out a mandatory duty to undertake natural asset management. As many of the folks on this call likely know, local governments are a level of government that is not explicitly provided for in Canada's Constitution. Instead, they are, by and large, creatures of statute. They are created by provincial statute and empowered by provincial statute to undertake the activities that they undertake. And so when we look to the question of, do local governments have the legal authority to undertake natural asset management, we need to look at the enabling legislation that empowers these local governments. When we look across the board, there's very little, with one primary exception, looking at the 4 sample provinces. There's very little in the legislation that explicitly says that natural asset management must be undertaken. At the same time, there's very little in local government legislation that says that local governments must undertake asset management more generally. So where does that legal authority come from where, by and large, local governments across the board are undertaking asset management? They may not be undertaking natural asset management. So where does this local government authority come from? By and large, what you see in local government legislation is similar language where essentially local governments, municipalities are created for specific kinds of purposes. The language of municipal purposes is used in many forms of legislation. And under those municipal purposes, there's generally a legal requirement to undertake everything that a local government can do, the provision of services, different regulatory authorities, to undertake those with certain principles in mind, principles such as good governance. And so in our view, the legal authority that local governments rely upon is generally that overarching principle that must be applied to all local government jurisdiction of operating with good governance principles in mind, with the municipal purposes that kind of start all the enabling legislation for local governments. So it's not explicit, it is implicit, with the one exception. In Ontario, there is a regulation that has been adopted, OREG 588-17, which explicitly sets out a legal requirement both to undertake asset management as a practice, as well as natural asset management. And what is really interesting about this is that it is the first instance in Canada where there is an attempt to explicitly recognize within local government jurisdiction the value that natural assets can provide to certain local government type services. It doesn't apply to all natural assets within the jurisdiction of a local government or a municipality in Ontario. It only applies to specific types of green infrastructure assets, which are, and I'll read out the definition here just to kind of give some more context. So a green infrastructure asset is an infrastructure asset consisting of natural or human-made elements that provide ecological and hydrological functions and processes, and includes natural heritage features and systems, parklands, stormwater management systems, street trees, urban forests, natural channels, permeable surfaces, and green roof. So it includes quite a lot of types of natural assets, but not all of them. So the kind of core message here is that in Ontario, there is a legislative obligation to implement natural asset management as part of an overarching legally binding asset management framework. This includes a limited subset of natural assets, and in Ontario, you can go beyond what is set out in this regulation, just like in local governments in other provinces in Alberta, in New Brunswick, in BC. You can undertake natural asset management under the kind of broad overarching municipal purposes that are supposed to kind of govern everything that we do. Now, one key challenge in this legal authority to undertake natural asset management is that by and large, across the board, local governments are legally required to undertake financial reporting in accordance with the Public Sector Accounting Board standards. And according to those standards, there are essentially restrictions on local governments putting a value on natural assets in their statements and in their financial reporting. So there are other resources that the Municipal Natural Assets Initiative has created, exploring some of the challenges with that and critiquing it and calling on PSAB to undertake some significant reforms to allow for the value of natural assets to be incorporated into financial statements of local governments. But this is kind of a key challenge that local governments face, in that one of the key planning processes that is utilized in an asset management framework is the financial component of what it costs to construct and maintain and essentially uphold all of the different assets relied upon by local governments for service delivery. And so one of the kind of responses here is that although it's not allowed within the PSAB requirements to include the value of natural assets as a tangible capital asset, there is still nothing prohibiting a local government from undertaking natural asset management. So, said a lot of words. The core message of this particular section is essentially that local governments can undertake natural asset management. There's nothing in the legislation that prohibits natural asset management. However, a barrier to this is the Public Sector Accounting Board principles that prevent the value of those natural assets from being accounted for as part of the legislatively required financial statements. And finally, in Ontario, there is actually a legislative requirement to undertake natural asset management within a certain kind of subset of natural assets. Excellent. So, legal tools available to protecting natural assets and to managing natural assets. So there are kind of two essential categories of legal and policy tools available as part of the practice of natural asset management. The first is those tools that can be used by a local government to establish a natural asset management framework. And then the second is the collection of tools that a local government can use to protect the natural assets that are relied upon by a local government to undertake service delivery. So the first of these, establishing a natural asset management framework, there are a great number of resources that have been developed by different provincial asset management bodies, by the Federation of Canadian Municipalities on what the kind of core components of asset management strategies, plans, policies, what they should include, what their purposes are, how they relate to one another. The one kind of gap that we noticed in undertaking the research for this particular primer is that there were questions that local governments were expressing around what is the legal effect of these different tools and what would be the value of adopting a natural asset management bylaw or an asset management bylaw. There are at least 2 instances in Canada where a municipality has undertaken the process of adopting an asset management bylaw. The city of Selkirk in Manitoba, and I'm seeing some questions here. Sorry, I'm gonna let other folks handle the chat while I speak, and then we can address those afterwards. But yeah, so there's the city of Selkirk in Manitoba and a municipality on Vancouver Island, Courtney, that has also adopted an asset management bylaw. And so we want to speak to essentially the legal value of undertaking the process of adopting a bylaw versus sticking with the standard and traditional instruments of policies or plans or strategies. And so the key value that a bylaw provides relative to policies, plans, and strategies is that a bylaw, by and large, is an outward-facing and externally enforceable legal instrument. So for local governments that want to add a heightened degree of legal accountability, a heightened degree of public accountability, that they will undertake certain degrees, certain types of asset management practices, certain types of natural asset management practices, they can adopt a bylaw that essentially allows a member of the public, if they so choose and if the right circumstances are present, to seek court enforcement of the obligations set out in the bylaw. Policies, plans, and strategies, in contrast, are not legally binding in the same manner. They generally should inform how senior decision makers and elected officials, councils, or regional elected bodies, how they should exercise their decision-making authority, but they are not enforceable in and of themselves in the sense that you can go to a court and get a court to issue an order that would enforce whatever the contents of these specific policy documents are. As we'll see later, they do inform civil liability, but they don't necessarily inform the legal obligations that a local government needs to undertake. The second kind of type of tools is the implementation of natural asset management. Implementation of a natural asset management framework, or more specifically, the protection of the natural assets that are relied upon by local governments for natural asset management and for service delivery. And these are the types of tools that I would assume many of the folks who are on this call are familiar with. They are tools that can be used for environmental protection, conservation more generally. There are tools that are used for many other types of instruments. And so the idea behind this is that these are tools that can be used with natural asset management as a kind of starting point or a lens through which we want to look at how we can use these things. Maybe, Roy, if you can go to the previous slide. So kind of starting at the highest level, we have land use plans and related instruments. By and large, across the board, there's a legislative requirement for municipalities to adopt some form of land use plan. In Ontario, it's called an official community plan. In Alberta, a municipal development plan. And it generally sets out how a municipality is going to be developed into the future. It articulates policies that should be taken into account as development decisions are made by senior decision makers and by elected officials. And with that instrument, with the land use plan, there is an ability to account for specific types of natural assets that should be protected, certain types of land that should be protected and should be set out in a land use plan in order to do so. And a key aspect of that is from a legal standpoint, a land use plan, although in and of itself generally doesn't have the same sort of legal enforceability as a bylaw, enabling legislation generally sets out that land use plans must, every decision taken underneath a land use plan, so for instance, a zoning decision, a zoning bylaw, all have to align with a land use plan. So if you set out in your land use plan that you are going to protect certain natural assets, then decisions taken underneath that in terms of development permits, in terms of zoning, all kind of generally need to align with that. Kind of next to that is zoning. You can more specifically, in a finer grain detail, protect certain natural assets using a zoning bylaw, protect the core elements of a natural asset, a wetland, park, forest, using zoning to clearly set out and communicate to the public that certain assets are important for the service delivery that a local government provides. One kind of key question that is often asked, and that the MNAI has encountered quite frequently, is how do you protect natural assets that aren't specifically owned by a local government itself? So privately held natural assets that are relied upon for local government service delivery. And these kind of two instruments, zoning and land use plans, are a key instrument in that, because it allows a local government to lawfully direct the ways in which land is used. There are limitations to that, and we'll get to that a little bit later, but those are kind of the key instruments for privately held land. Another way of dealing with that is actually just getting an interest in the land. So purchasing the land, getting a conservation covenant or easement, depending on where you are, different terms are used for the same thing, where essentially a piece of land is restricted from being used in certain ways, or subsets of that land are protected from being used in certain ways to protect certain aspects of that, usually from a conservation standpoint, but there are creative ways to use those tools to protect different kind of elements of what that land can provide. Next slide here. And then, these, again, kind of the broad umbrella of tools available to local governments for doing everything that it does can generally be used in a manner that advances natural asset management and protects natural assets. And so we have seen local governments establish committees or commissions with the specific purpose of undertaking the natural asset management process that local government will undertake. So essentially finding people with the very specific types of expertise needed to identify the natural assets that a local government relies upon, setting out levels of service that those natural assets will provide, and then also guiding or providing recommendations to senior decision makers and elected officials on steps that should be taken, legal steps that should be taken to protect that, those natural assets. Financial tools, we've seen local governments create environmental levies that will create a pool of funds available to maintain certain natural assets. Gibson's in BC has used development cost charges to essentially raise funds to maintain natural assets that provide certain stormwater related services that an engineered asset otherwise could have provided. So within their jurisdiction to impose development cost charges or development charges, as they're known in other provinces, there's flexibility to allow for the raising of funds to provide maintenance services to assets to allow for that degree of additional protection. And then kind of what we have here are miscellaneous bylaws. So local governments generally have a very broad degree of bylaw making authority to essentially accomplish their municipal purposes. And the list that we have here, nuisance bylaws, tree protection bylaws, soil deposit or removal bylaws, pesticide bylaws, all can be used in certain ways to protect natural assets that the local governments rely upon for service delivery. And so kind of a key message here, and I'll ask Ray to go to the next slide here, is that one of the tools that the Municipal Natural Assets Initiative has developed and used with a number of its partners is the development of a natural asset inventory. So essentially identifying all of the natural assets that a local government relies upon for the services that it provides. What I would recommend as part of that process is that as you undertake the process of identifying these local natural assets that are relied upon, you also undertake a legal assessment of those assets to identify who owns them, what is the legislative regime applicable to them, what ways in which the local government can adopt different legal instruments to protect them, which ways can bylaws be amended, or what kinds of bylaws can be adopted. Essentially, while you are identifying the things that are important for service delivery as part of a natural asset management inventory, you also identify strategically what legal next steps you can take, because there are a plethora of legal tools and policy tools available to local governments that all can be creatively used to protect these natural assets. And it's just a matter of finding the ways that work for those specific types of natural assets that you have in your own particular jurisdiction, and doing so in a way that mitigates the legal risks, which is our next section here. I'm just going to quickly check the time. Excellent. So what we have here is the types of legal actions that local governments generally find themselves facing most often. We have the public oriented legal actions, where the decisions of a local government body can be challenged for legality, for reasonableness, judicial review as it's commonly referred, but there are also kind of other alternative routes to challenge those types of decisions. And then private causes of action, where a local government can be held liable for specific decisions it has made, or where actions or the lack of an action has resulted in harm to a resident, to a business, to a neighboring municipality. So each of these things can apply in different ways to natural asset management. And kind of in the interests of time, I'm going to essentially just highlight that, like anything that a local government does, there's some degree of legal risk to acting and to not acting. And when it comes to natural asset management, there is, in my view, no greater risk relative to the alternative of not undertaking natural asset management. It's just a matter of managing the risks that a specific course of action entails. And so, for instance, one of the core aspects of natural asset management is this idea that there are certain ways in which a natural asset can provide equivalent or better services than an engineered asset. There are all sorts of best practices available for identifying the ways in which engineered assets can provide those services, the levels of service that are reasonably expected, the ways in which costs can be allocated to construction and maintenance of those engineered assets. And admittedly, there are less resources available for that sort of analysis for natural assets. That doesn't mean that a local government cannot undertake that process of trying to look for equivalency. It's just a matter of identifying what is the best information that we have available to make those decisions. What are the ways in which we can mitigate our risk of, for instance, being held liable for nuisance or for negligence? And it's a very legal thing to say, but talking to your legal counsel and finding a strategic way of using the tools available at your disposal to manage those risks is kind of the best thing you can do. As I said, I don't think that there is any greater risk of undertaking natural asset management. It's just a different type of analysis. And essentially, kind of going back a few slides here, one key benefit of undertaking that legal analysis as you undertake the creation of a natural asset inventory is that you can start early on by identifying what are the ways in which you can mitigate those specific legal risks associated with different types of assets. And so what I might suggest, because I'd like to ensure that we get Q&A, if Roy, can you go to slide 23?
I can't see the numbers, so you'll have to tell me when.
Okay.
I hit 23.
Sure, it's when it starts to look gray again. There we go. So to kind of close us out, I want to highlight some of the legal developments that I think local government should be aware of as they question whether or not to undertake natural asset management, and also how to undertake it or how not to undertake it. Kind of if I could summarize everything up until this point, it's essentially that local governments can undertake natural asset management. There are legal risks associated with doing so, and there are legal risks associated with not doing so. All of these legal risks are manageable, in my view. It's about identifying first, what natural assets do you rely upon for specific kinds of services? And then what are the legal tools that you can use to protect those, to protect the value that those natural assets provide? But all of this is being said in light of a rapidly shifting legal context that in general is recognizing nature as a more valuable part of the decision-making framework within a wider context of a climate and biodiversity crisis that is exposing local governments to significant costs that they may not necessarily have the resources for, or an established level of resilience to respond to. And so, kind of to close us off, I want to highlight some of the legal developments that might force local governments to act in certain ways that are more aligned with this idea of natural asset management. The first of these is developments in Indigenous law and legal developments in relation to Aboriginal law. At least in BC and in Canada, we have legislation where the United Nations Declaration on the Rights of Indigenous Peoples has been incorporated into law, and those two governments have also undertaken a legal obligation to align all of their pieces of law, their legislation, their regulations with the United Nations Declaration on the Rights of Indigenous Peoples. And what that essentially means is a fairly transformational shift in our legal systems. By and large, Canada is often thought of as a bijural state with civil law in Quebec and common law in the rest of the country. But in reality, there are dozens, if not hundreds, of legal systems that have operated since prior to colonization that are increasingly being seen as legally enforceable in relation to the Crown legal systems of common law and civil law. We have recent decisions of the courts in BC that have recognized the effects of cumulative decisions allowing industrial development on treaty lands that have essentially recognized that essentially the cumulative effects of development decisions, be they industrial or municipal, on treaty rights must be taken into account, and a significant response of that has been increased recognition of the co-governance authority of affected Indigenous nations. And then we also have a significant number of Aboriginal title cases that are working their way through the courts that could fairly significantly affect who exactly has jurisdiction over the natural assets that local governments rely upon, both either within the boundaries of a local government or beyond. Because as we know, natural assets, a watershed, for instance, does not respect the boundary that we put out for ourselves in local government management. And so we have decisions coming or expected to come out in BC, in New Brunswick, that are likely to recognize Aboriginal title, in my view, over a significant swath of the country, and it's going to affect it's going to affect in a significant way the jurisdiction over natural assets and also just jurisdiction more generally. And it's something that should be responded to now before the decision, these decisions come out. But essentially here, Indigenous governments have an inherent right of self-determination and an inherent right of self-government that is increasingly being recognized and increasingly being exercised, and it is affecting local governments in significant ways, and it's going to affect jurisdiction over natural assets that are relied upon by service delivery or for local government service delivery. Next slide. We also have a number of decisions working their way through the courts that are seeking to recognize environmental rights. In Canada's Constitution right now, there is no recognized area of jurisdiction over the environment. It's a shared area of jurisdiction between the provinces and the federal government. But environmental groups have for a long time and continue to seek expanded interpretation of the Constitution, of the Canadian Charter of Rights and Freedoms, to include a right to a healthy environment, or to include recognition of nature as holding rights, as expansion of constitutional principles that essentially put an obligation on the federal or provincial governments to undertake actions that maintain the environment in certain ways. And although none of these have been successful thus far, there are a growing number of them being brought forward in the court system. There is one particular decision that we are waiting for a decision on out of Ontario, where a group of youth have challenged Ontario's climate policy for its sufficiency and have argued that their charter rights, specifically the right to life, have been violated by the inadequacy or their alleged inadequacy of Ontario's climate policy. We also have a number of decisions responding to significant climate emergencies that, again, have not yet been decided upon, but are, in my view, a bellwether for the types of decisions and actions that we are likely to see going forward as more and more folks are harmed by climate-related crises, by fires, by floods, by droughts. So there are two particular class actions that we've highlighted in the primer: the Sumas Dike class action, and as well as the Oakville flood class action. The Sumas Dike class action relates to the 2021 atmospheric river, and the Oakville flood class action relates to the effect of upstream development decisions on downstream development. And all of these are seeking to kind of push the scope of negligence and nuisance in creative ways to recognize the value that nature provides. And then kind of finally here, in the next slide here, Roy, we have a couple of other legal developments: the Rights of Nature movement and Ontario's recent More Homes Built Faster Act. The Rights of Nature movement, as Roy alluded to earlier on, is a movement seeking to grant legal personhood or recognize legal personhood for natural entities like lakes, rivers, forests. There is one instance of a local government and a First Nation in northern Quebec recognizing the Magpie River as a legal person. And this idea, it's very early on in the process of recognizing nature as a legal person. But the idea behind this is certainly gaining traction. It's gaining traction around the world. There are several countries that have adopted legislation or amended their constitutions to recognize these, and there are several communities across Canada that are also actively exploring what this could look like in their own particular areas of jurisdiction. And then finally, I think a lot of the folks on the call from Ontario probably have heard the significant criticisms of the More Homes Built Faster Act and its effect on local government jurisdiction in relation to environmental protection. I think a critique or an assessment of that whole legislation is beyond the scope of this, but it's something to be mindful of as we move forward, and that sees implementation, the ways in which it could compromise natural assets and potentially expose local governments to liability in the future if there are certain harms caused as a result of decisions that fall under that particular piece of legislation. And so what I might suggest is we go to Q&A here. We just kind of have the key conclusions here, which I think I touched upon earlier, which is essentially that local governments can undertake natural asset management. Ontario municipalities must undertake natural asset management to a certain extent. There are plenty of tools available to do this. Working with legal counsel to identify the ways in which those tools can be creatively used to mitigate risks is a key step you can undertake, and that these legal risks are no less manageable than the legal risks associated with not undertaking natural asset management. But given the high level kind of shifting trajectory that we're seeing with the climate and biodiversity crises and all of these larger environmental movements that we are needing to respond to, there is a stronger policy argument for undertaking natural asset management. All right. Thank you very much. That was a whirlwind of information. And so we can do some Q&A. I'm going to look at the chat here, but if anyone wants to ask a question, feel free to pop it in the chat, or you can unmute yourself and also ask on here.
And if you're digesting and come up with questions later, my email and Ian's appear on the screen. So we will do our best to respond to questions after also, but we do have a few minutes now.
Thank you all for those of you saying your thank yous in the chat. I think one thing I might add on, and this is, I know, a question that MNAI has received is, you know, what about local governments that have access to information about natural assets they rely upon, but don't necessarily act upon that information? Is there a legal obligation to do something about that? And I think, you know, to give you the short answer is the legal answer, which is it depends. But kind of to unpack that a bit, there are legal risks to not acting on the information that is out there. That there are legal risks to not recognizing that local governments are already relying upon natural assets for service delivery, and so failing to undertake any sort of systematic approach to recognizing that value. If something happens in the future, for instance, if a development is allowed that undermines a key natural asset that prevents or provides some sort of stormwater management or flood protection, there could be a risk associated with having made decisions with that information in the kind of in their back pocket, and a failure to protect the assets that were relied upon that could have prevented, say, a flood. So you know, there's a much more nuanced answer behind that, but it is a common question of, you know, what do we do with this information, or what should local governments do if they have access to that information but they aren't necessarily acting upon it? And I think my takeaway is you should act upon it.
I have a question, Ian, and we've sort of talked about it, but what if a local government doesn't ask the questions, but in the face of growing number of climate crises, reasonably should have asked the question about the kinds of services that nature should have provided? What happens? I mean, is ignorance a good defense?
Generally, no. And I think that the answer in many ways depends upon decisions that are going to be coming out of the courts in the near to medium term. I think that there is a growing movement of environmental groups, of citizens trying to hold governments accountable for failure to take into account information that we have had, exposed risks that we've been undertaking, or risks that we've been exposing ourselves to under the climate crisis, under any sort of other environmental crisis that we're facing. I think that there is eventually going to be a moment where the courts do recognize that we've had this information, action should have been taken, and that governments now need to respond. So that's kind of my takeaway, that maybe not now. Governments are likely kind of covered now, but the trajectory of the law is generally in the direction of it's not going to last forever, and that government should be mindful that I think that it's going to happen sooner or later.
Okay, thank you, Ian, and maybe I think that's a great note to close on, to kind of misquote Wayne Gretzky. I think this primer tells us a little bit about which way the puck is likely to be going. So Ian, I'd like to thank you very, very much for all of your work. I'd like to thank everyone who's on the line for attending. If you have additional questions, then by all means, please shoot them to the emails that are on the screen. We will be looking for other opportunities to share this, but please also share widely within your own networks. We'll be hitting up a couple of legal journals and looking for a couple of conference opportunities, potentially, to make sure elected officials hear this also. So a big thank you to everyone. Hopefully this was useful. Again, as we said at the outset, it's the start of a journey, not the end, and there's far more questions to be asked and answered, and we'll be looking into those also. So thank you, one and all.